Welcome to a Zoom oral argument at the 5th District Court of Appeal. I am joined on the panel today by Judge Harris and Judge Kilbane. See, first on our docket today, I believe it's Smith versus Smith, 22-2699. Is that correct, counsel?
Yes.
Yes, Your
All
Honor.
right. So we have 20 minutes on each side. Counsel for appellant, if you'll just let me know how much time you would like to have in rebuttal, we will try to remind you. It's of course your responsibility to watch the clock, but I will try to remind you as we get to that time. With that, counsel for appellant, you may proceed.
Yes. Thank you. May I please the court, Rebecca Creed of Creed and Gowdy, on behalf of the appellant cross appellee Shanley Smith. I'd like to reserve 5 minutes for rebuttal. The trial court erred for 3 main reasons. First, the trial court misinterpreted the plain language of the postnuptial agreement when it refused to exclude the specifically set forth herein assets from an overall equal distribution and division of the party's marital estate.
Counsel, can you address the double counting issue first, please?
Yes.
It seems like sometimes these accounting sort of errors or alleged errors are difficult to necessarily get a handle on. It seems like your opposing counsel argues that not that there wasn't a double counting, but just that the record does not sufficiently establish that happened. Do you agree that that's counsel's argument? And then either way, could you address that?
Yes, it does appear to me that that is counsel's argument, that somehow we didn't specifically prove that the 2018 joint tax liability was paid from marital funds. But we would argue, as we did in our reply brief, that's directly contrary not only to the evidence at trial, but also to the husband's own assertions in his proposed final judgment, which the trial court largely adopted as to how those striker proceeds were to be treated. The husband testified at trial that he paid the 2018 joint tax liability of $950,000 directly from the striker proceeds, which he had taken those monies and deposited those into a Wells Fargo account. And then he introduced an exhibit at trial, which was at pages 25, 28 through 29 of the record, husband's exhibit 21, that specifically listed the summary of the marital debts and expenses paid from that striker payment, which included the 2018 joint taxes. And so in this respect, the trial court adopted the husband's proposal that those 2018, that payment, that credit, was a credit to be given from the otherwise marital value of the striker proceeds paid to SS Fusion. And so the husband was entitled to that credit as if there was, and it was a marital liability paid from marital funds. That was the husband's argument. And at trial, that was the argument that the wife agreed to, that should have been not included and not counted against the husband in equitably distributing those striker proceeds. But where the error comes into play is on page 31 of the amended final judgment, which is the equitable distribution schedule. And there, again, the trial court adopted the husband's proposal, but it not only valued SS Fusion, those proceeds, to not include or to give husband a credit, basically, for payment of that marital debt from marital funds. It then gave husband a separate line item credit of $950,000 for the 2018 joint taxes. And it's
okay, and certainly I've read this, but let's go over it here. How was the 950? How does it relate to the valuation of SS Fusion as the trial court calculated it?
It relates to the value of the striker proceeds that were, both parties agreed that those proceeds were a marital asset that should be evenly divided. Where that issue comes into play is in the valuation of what should be deemed marital value of those striker proceeds and what should not. And because the husband had, in the trial court's view, and as the husband argued, properly used those otherwise marital assets to pay a marital debt, then in essence, that $950,000 was not counted against the husband in what was otherwise dissipated value for purposes of establishing the value of the marital asset. And so the husband was given a credit for that $950,000 payment from marital funds, but then again, separately given a separate line item credit for the $950,000 as if he had paid that individually or paid that from his personal funds. And so it is that double counting essentially of a credit, unlike the cases that we cite and rely on, which I do think are applicable to this situation and explaining how there can be double counting here. And instead of basically counting an asset against the husband twice, like in the Stearns case, both as part of an adjusted cash value of a company and also as if he owned and still owned that car individually. Here it was basically a credit. It was a subtraction that was counted, a credit
Sure.
it was counted twice.
Just do the, and look, the briefs do this. I acknowledge that, but for our benefit here, walk us through the math, the actual math as it relates to the SS Fusion side.
So
Show us the math that shows that the 950 was credited on that side of the balance sheet.
it was, I mean, we do address this in detail, and I would also rely on our briefs, but where it comes into play, and we explained based on the language of the amended final judgment, which again was proposed by the husband. The trial court started with a presumptive potential marital value of those striker proceeds of $3.9 million. The total paid to SS Fusion by Stryker was $5.2 million, but the trial court discounted certain of that value, which said was not really a potential marital value. So the trial court started with a $3.9 million in marital value. And then at the husband's urging, instead of equally dividing $3.9 million, and instead, or even less than that, the trial court accepted the husband's interpretation that that $3.9 million was in fact reduced by this $950,000 payment.
Well, hold on, just so so essentially the argument was the 3.9 is no longer there, right?
Well, that was
It's
part of
been
our argument,
spent.
which is a separate
Well,
argument.
hold on. Part of that's been spent. That was the argument, right?
Right.
Okay. So if it's not there anymore, you can't distribute it. So now you had to figure out, right, what kind of expenditure was it? Was it marital or not, right? So 3.9. Now walk us through the numbers.
So 3.9. So in terms of valuing that asset for purposes of distribution to be evenly divided, those Stryker proceeds, the trial court accepted that husband had paid $950,000 towards the party's joint 2018 federal income tax liability. That's just record page 4110, page 17 of the final judgment.
And that's from the 3.9 that the trial court concluded was marital.
That could have been the potential marital value, yes. And that was paid. That was also shown. The husband testified at trial that he used the Stryker proceeds that had been deposited in that Wells Fargo account, but nonetheless retained their marital value to pay the 2018 joint tax liability. That's his own exhibit and his own testimony. So the court decided it could not include an equitable distribution of the value of funds spent during the pendency of this case unless those funds were dissipated for a non-marital purpose. So necessarily in determining what the dissipated value should be, the court did not include that $950,000 because that was properly credited as payment of a marital debt from marital funds. Payment of the parties' joint tax liability is not dissipation, and that amount will not be attributed to husband for equitable distribution purposes. So what the court then did was it added up amounts that the husband conceded had been dissipated, which included a $700,000 paid to his then girlfriend and a $1.2 million paid for 2019 taxes, which were his own separate tax liability, and whatever the value left of that original $5.2 million, which was a little over 15,000. So that's how the trial court got to the 1.9 million as opposed to the potential 3.9. But in doing so, it, at the husband's urging again, basically gave the husband a credit as if he had, which he testified he had paid the striker, from the striker proceeds, he had paid that 2018 joint tax liability. And then it also, again, on page 4124 of the record, then also gave him a deduction for the 2018 joint taxes as if that was a separate and personal credit. So again, he was credited twice. It was the husband's own testimony and his assertions to the trial court and his representations and his proposed judgment that the trial court accepted to find that those funds were paid towards the party's income tax liability and could not be included in equitable distribution as dissipated funds. If I may, I'd like to return to our first argument, which is that the trial court erred in misinterpreting the language of the postnuptial agreement. The postnuptial agreement in paragraph 6E and as followed in the separately subparagraphs 1 through 9 specifically set forth assets that were not to be equally divided as marital assets. Those assets range from certain identified business interests to the marital residence, to the wife's vehicle, jewelry, jet and boat skis, or boat and jet skis, and the wife's mother's condo. So it is our contention as set forth that the trial court did not give a fair reading of this postnuptial agreement when it seemed to presume and it decided that the parties must have intended to equally divide all the marital assets, despite the specific language that accepted or exempted from equal division these certain specifically defined assets. Certain of those assets were to become the wife's sole assets upon dissolution. Others were to become the husband's. And rather than specifically distributing those assets outside of an overall equitable distribution scheme, as the parties intended, the trial court presumed that the parties must have intended to equally divide everything, just as if they had been governed by section 61.075 of the Florida statutes. We do emphasize that this language, the trial court essentially disregarded the language of that, except as specifically set forth herein provision of paragraph 6E, and essentially just treated everything as if it should be equally divided. But wife argued at trial and presented in her own proposed final judgment a scheme or set forth the manner in which the assets should be distributed directly to one party or another as defined in those subparagraphs 1 through 9. And only then should the remaining assets be equally divided. And what the effect of this was that the trial court basically used the 110 Astura shares, which should have been equally divided, used those shares to basically true up or even up the allocation to the wife of the marital residence. So that resulted in the trial court not following the plain language of the postnuptial agreement. The trial court agreed with the husband that because the word unequal doesn't appear in the agreement, or because there was no, what the trial court viewed as specific exclusion from equitable distribution, that the trial court, or that the agreement must have been intended as an overall equal distribution. But the specific language of except as specifically set forth herein does accept or exempt those, certainly those specifically defined assets from otherwise being divided equally. And for a party to become a sole owner is not consistent with an equal division of an asset. The trial court's reading also disregarded the other language within the agreement, which we set forth in detail in our briefs, that indicated that the parties had agreed to waive certain rights to which you'd otherwise be entitled to in terms of how the assets were to be distributed. And also disregarded the Florida law that allows for parties to agree in a postnuptial agreement as to how assets should be divided. I see that I'm almost into my rebuttal time, so I would ask the court to consider my briefs as to these other issues, and I'll reserve my remaining time for rebuttal. Thank you.
Thank you, counsel. All right, counsel for the appellee, you may begin whenever you're ready.
Thank you, Your Honor. I please the court, and because of the cross appeal, I want to tentatively reserve 2 minutes for that. We'll see how that turns out at the end of my main presentation.
Okay.
The court expressed concern about the $950,000 figure. So unless the court prefers somewhere else, let me start with that quickly. What's significant, I believe, in the testimony was that the husband said he paid it from that Wells Fargo account. Now, the Wells Fargo account was not static in the sense that only the amount that was derived from the termination agreement with Stryker was involved. There were debits, there were credits, there were other payments coming in and out. There were even bad investments made. That was one of the things that the wife complained about, that there were some losses based on investments that the husband
Counsel,
made.
did the trial court calculate that 950 into the SS Fusion, into its evaluation in SS Fusion?
It appears to be, Your Honor, but Your Honor asked, show us the math, and which was a
Well, I guess my first thought there is that if the trial court included the 950 in its evaluation of SS Fusion, then are you challenging that the trial court's doing so as a matter of competent substantial evidence? Are you arguing on cross appeal that there was no competent substantial evidence for the trial court to do that?
The cross appeal, Your Honor, does not involve
Right.
the termination agreement. That the cross appeal only dealt with some
Right.
post judgment.
So I guess the problem for you on that argument you were making there is that if you didn't raise it on cross appeal and the trial court did it, then I'm not sure you can get there right on that point. So the question is, if the trial court included the 950 in its analysis on SS Fusion, why isn't that a double counting?
Because it is to some extent unclear about how exactly the reductions from the termination payment were made. Your Honor asked about the math.
Yeah.
So briefly, and I'm not trying to be repetitive of counsel's argument, there were 2 payments made. There was a $4 million payment that was made initially as a result of Stryker terminating the distribution agreement with SS Fusion. There was a subsequent $1.2 million payment that was made in contemplation of Mr. Smith transitioning the staff from SS Fusion to Stryker and other post-petition non-marital services. There was also a $100,000 specifically enumerated amount attributable to the extended non-compete. He was originally SS Fusion was originally under a 12-month non-compete.
So the top end number was 5.2, right?
Correct.
Okay,
Correct.
now start walking, but it wasn't 5.2. That wasn't the value of SS Fusion, the marital value anyway, correct?
That's how we got to the 3.9.
No, but nope. 5.2 minus what? Walk us through it.
That's what I'm saying. 5.2 minus the 1.2 million, which was the post-petition services.
Right.
$100,000 for the non-compete as enumerated in the agreement. which gets you to the 3.9.
Okay.
Then the amended judgment refers to certain expenses, but it does not specify with exactitude as to the dollar how many dollars Mr. Smith used from those funds in order to maintain the support of the family during the extended period of time that the case was being
You're
tried.
talking about the 950 now.
No, sir, I'm talking about you asked about how do we get to the
Okay.
number.
Let's get there. How do we do it?
I'm trying to get there.
Okay.
So the husband's exhibit 14, which is found at R2497, set forth that the husband had paid since the October 2018 date approximately $1.168 million, which included paying the wife's American Express card every month, direct monthly expenses for the marital home, mortgage, taxes, insurance, etc., the schooling for the children, everything whatsoever for the wife's expenses. The court makes a reference to those expenses at page 17 of the amended final judgment, which I have at R4148, but doesn't expressly say how much of the amount was attributable to simply expenses for wife and children. Of course, the husband had his own expenses. And Judge Eisnagel, we also have to remember, this was at the same point in time where the husband had lost his significant source of income. So he was basically put on the bench and had some other ancillary income coming in from other sources that would not trigger the non-compete. So when you ask where does the math come from, I can only tell you that there was testimony that expressly showed that there were numerous expenses that he paid out. He paid for his own support. He paid the 1.16 for the family support. He paid those monies that he agreed and acknowledged at trial should be attributed back. That was the loan to the girlfriend and the $1.2 million that he paid to pay his 2019 federal tax liability. So what the court did in the amended judgment and the court expressly stated the $1.2 million for the 2019 taxes, stated the $700,000 payment, and the husband acknowledged those should be attributed to him. And you took those two figures and you added what the then remaining balance in the Wells Fargo account, which was $15,000 and change, and that's how we got to the $1,915,000 and change. That's how the number got there. But so to your Honor's question, the court makes an express finding that the monies that he spent for his support, for the wife and the children's support, and these other expenses would not be deemed as dissipation. So that wasn't going to be charged against him. The money to the girlfriend of the 2019 taxes were.
Is that a way of saying that is it your argument that the $950,000 was not actually calculated into the marital value of SS Fusion?
It's referred to.
No, hold on. No, just help me understand this by answering the question yes or no first, and then provide your explanation, because that would be the most helpful. Was the $950,000 calculated into the marital value of SS Fusion?
When your Honor uses the word calculated, I take it as I've got a list of figures, figures X, Y, and Z, and it adds up to something.
Well, calculated, the 1.2 was calculated into it,
yes,
right? The 700,000, hold on, the 700,000 was calculated into it, right?
Correct.
Yes. The 100,000 was calculated, right? Yes or no?
For the non-compete. Yes, sir.
Was it calculated into it? What did the trial court use that number to calculate the value?
That's how that was part of the way that the court got to the 3.9 million.
Yes. So the answer is yes, right?
That's correct.
Was the $950,000 calculated into the marital value of SS Fusion? Yes or no?
I can only tell you what the court said.
Okay.
And this is the direct quote, and it says husband also paid $950,000 towards the parties.
Yeah, I've read that, counsel. I guess I'm asking, is there any calculation based upon the trial court's the starting number and the end number? Is there any way that hold on? Is there any way that the $950,000 was actually calculated into the trial court's final number for the marital value of SS Fusion?
You could say only, I say no, only because we don't have a specific number that were the other components that got us to, in essence, zero or 15,000 not, if that makes, in other words, the court said, we're left here with the 15,900 figure left in the Wells Fargo account. And of course, there were debits and credits unrelated to those expenses that dealt with that. The court didn't, as I said a moment ago, the court didn't do a table saying, with math that says.
No, I understand there's no table. That would have made this real easy, right?
Yes, sir.
And there's no table in the briefs. But I guess the question is there any way to calculate the numbers what was the trial court's final number for the marital value of SS Fusion?
The marital value was attributed to be $1,915,908.40.
Now, is there any way when we go from 5.2 to the number you just said, is there any way that 950,000 was calculated into the analysis to reach the 1.9 and change?
It would appear so, and as I said,
that's what we've been trying to get now for 10 minutes. Okay.
But Your Honor, the only variable that I mentioned to you is because the court simply said that there were other expenses that he
But
paid.
counsel, if the numbers work, you combine, if the numbers work, how does, okay, let me ask you this question. How do you get to the 1.9 and change without using the 950?
You look to the amounts that he paid for the family's benefit, as I mentioned before.
Okay.
You look to the amounts that he spent for his own support during that same period of time. You look to certain investments that he made in not the Astoria, but some other investments that he made.
I guess those are all very vague statements. Can you give me numbers? Do the math for me. How do you get to that 1.9 and change without putting the 950 in there?
I'm not sure that you can with exactitude, and that's what I tried to say a few moments ago.
But isn't that a problem for you, though? Isn't that a problem for your position on appeal?
Well, it's an issue that if there's substantial competent evidence that shows in the record.
You didn't challenge the substantial competent evidence, counsel. You didn't challenge the trial court's findings here.
Well, we had prevailed on it, and I recognize there is some law that says that.
Right, but if you want to take issue, I mean, that's what a cross appeal is for, right? If you want to take issue with findings that the trial court made and say, hey, those aren't supported by evidence, don't you have to file a cross appeal?
I understand the court's question. Okay. So I think I've exhausted the best I can explain to Your Honor where the 950 came from. As I said, ultimately, I would suggest it was still a matter of proof for the wife to deal with. As to the actual postnuptial agreement, counsel argues that all the court did was basically effect equitable distribution as would have been required under 61.075. Respectfully submit that's not the case. She did, in fact, receive benefits under the agreement, not only a substantial alimony award under what would be deemed as a moderate term marriage, but she also received the certainty of knowing she was going to receive the marital home. One thing that's important to remember, Your Honor, is that at the time the agreement was entered into, the large subsequent marital home on the Intercoastal Waterway was only a lot. It had not been constructed. And so what did the wife receive? She got assurance that whatever happened, if there was a dissolution of the marriage, she would get that. It didn't say she would get it separate and apart. It didn't say that that's over and above everything else that she gets. She avoided the possibility that the husband could either argue for a special equity of some kind, as that law existed at the time. He could have argued for partition of that home. There are any number of benefits that she received by having the assurance that the marital home, whether it was the previous one or the subsequent one, was going to be awarded to her. And as the trial court, I think, correctly found in the judgment when interpreting the terms of the postnuptial, says, and I'm just quoting directly, the court finds no mention of any unequal division of the marital assets. While the postnuptial agreement does indicate which party should receive certain assets, it does not anywhere state that any of those assets are to be excluded from the equitable distribution schedule, or that the parties otherwise intended an unequal division or distribution of the marital assets. Now, what's significant about that is counsel talks about the language as except as specifically set forth herein. This is the rub that the wife is having to rub up against. At trial, a significant amount of the time spent and a large focus of the testimony dealt with whether the SS Fusion corporate entity had been sold. And why was that so important to the wife? Because there's a specific provision at page 2456, which is the page of the postnup, that says that if one of the business entities that were identified in a certain category, which included SS Fusion, was sold, traded, or exchanged, then she gets, in essence, the first $2 million off the top, and then the rest is equally distributed. That's why that was fought so hard. And that is, Your Honor, I would suggest to the court an express reason. That's the except as specifically set forth herein. In other words, the preamble, which we can't ignore, to Section 6 of that postnup specifically acknowledges that the parties intend to have equal division of their assets. But what the wife was able to obtain successfully was assurance that she was going to get the marital home. She was going to get some of the other assets, the boat, the jet skis. She also got the condominium that her mother was residing in. And what's interesting about that, and it has some bearing on the cross appeal, is that the husband was obligated under the postnup to provide a payoff to that condominium mortgage within 30 days of the entry of the final judgment. That was something that would not have happened had they gone to trial. So, and it also shows that when the parties know how to set forth a deadline, they know how to do it because they did it with respect to the condominium that the mother resided in. So with that said, the wife respectfully utterly failed to show that there was a sale of SS Fusion, because it was simply Stryker making the determination that the distribution agreement was going to be terminated. The wife was trying to counter the testimony of Dr. Don Wiggins, who was a very respected expert in our area, who specifically said unequivocally this was not a sale, and therefore SS Fusion just goes into the mix. She doesn't get the first $2 million off the top. During the trial, the wife attempted to obtain a lawyer in Jacksonville to rebut the Wiggins testimony. He couldn't do it. In fact, he even ultimately admitted, when asked on cross-examination, was SS Fusion sold? No, it wasn't. So the court correctly accepted the Wiggins testimony as to that. And that's why it's so significant, because the fight over the SS Fusion indicates that the other assets were in fact supposed to be distributed equally. In the 2 minutes I have left, I just wanted to speak briefly about the cross appeal. Again, nothing in the postnup said when the marital home mortgage was to be satisfied. Under these unique facts, we submit that it was an abuse of discretion for the trial court to have imposed that requirement, knowing that the husband was really cash strapped at that point. Wife complained because he made an investment in a medical spa business. He had to. The wife had basically torched his business with his referring physicians and with other referral sources. I would suggest to the court it was an abuse of the trial court's discretion to not allow the husband to have a short period of time within which to satisfy that mortgage.
Counsel, how long? I mean, if 60 days isn't enough, what wouldn't have been an abuse of discretion?
He suggested at the hearing, Your Honor, that if he had 6 months, he thought that the spa business would root itself and be successful enough that he could make the payment at that time. And Your Honor, also he agreed to put a stop on the sale of any shares. He would, encumber them so they couldn't be transferred. That would in essence be the wife's security. And of course, he was paying the mortgage the whole time. There was no harm to the wife if the court had given him just a little bit more time. He ultimately had to sell his stock into a very depressed market, which a depressed market that the wife herself recognized she didn't want to sell into
No,
either.
I know what the request was. Where's the line? Where
The line is
did the trial court have to go the full 6 months requested to avoid abusing its discretion?
discretion is a hard thing, Your Honor. I would say Ms. Creed probably has a different view of discretion than I do. We would submit that some amount of time was warranted, and he didn't get it. I'll reserve the balance. Thank you, Your Honor.
Okay, counsel, you have 4 minutes, 57 seconds.
Thank you. May it please the court. First, as to the $950,000 credit, the trial court accepted the husband's proposed judgment. It was the husband who proposed this language of crediting the $950,000 towards the party's joint 2018 tax liability. The fact that it was paid from the Wells Fargo account, which included the Stryker proceeds, is best reflected.
Counsel,
by
does it matter who proposed the language, or does it matter that the trial court made the finding and there's no cross appeal?
Both, respectfully. I think.
Okay, all right. Which matters more? Which one matters more?
I think it matters more that there is competent substantial evidence to support what the trial court did, and that the husband does not appeal that determination or cross appeal that determination. So it's not simply that the husband proposed this language that the trial court accepted, and it is that there is competent substantial evidence to support that, as shown by husband's exhibit 21, which lists January, February 2019, the deposit of $5.2 million. And then in April 2019, shows a withdrawal of $953,000, which was listed for the purpose is 2018 joint taxes and bank charges. So that is clearly set forth in the testimony. And essentially it is, the way that it was accounted for was to give the husband a credit twice. It was not determined to be counted against him as dissipation. It was counted for him as a credit, as a payment of a marital debt from marital assets, and then again counted as a credit to him by having that separate line item deduction for the 2018 joint taxes. As to the equitable distribution, while the wife did receive alimony under the postnuptial agreement, there were other instances where the court clearly did not follow the plain language of the agreement with respect to the equitable distribution provisions. The language of the preamble focused on the party's desire to create an economic partnership coexistent with the emotional and legal bonds of their continued marriage. But this agreement goes on to specify what happens in the event of a dissolution. And the continued marriage, the parties did recognize that the postnuptial agreement itself, the consideration for that postnup was the wife's agreement to forego the filing of a petition for dissolution in 2015 for the reasons stated. And so it's not simply that everything should be divided equally. There are specific exceptions. The except is specifically set forth herein language, which were to accept certain assets otherwise from being treated as marital assets to be divided equally. The husband focuses on the SS Fusion sale. We don't appeal that determination by the trial court that there was in fact no sale of the business entity itself. But we do focus on the fact that the specifically identified assets were to be distributed directly either to husband or to wife, and in certain instances with the marital residence free and clear of any mortgage debt, which we submit with relation to the cross appeal could have allowed the trial court to immediately order the husband to satisfy that mortgage debt on dissolution. Instead, she tried to give him a break and gave him 60 days, which he still didn't follow. As of the time of the June 2022 hearing, that had been much more than 6 months from the original deadline, more like 8 months. And even after being ordered to satisfy that mortgage debt within 30 days of the middle of June, the husband still waited until September of 2022 to satisfy that debt. So there was no abuse of discretion. The trial court heard the husband's testimony at the trial hearings on the enforcement issue and determined that he was not credible, that he was very evasive, and that she had listened to what he had spent his money on instead of satisfying the mortgage debt. There are other provisions within that paragraph 6E that also relate to the division, and when the parties intended for an asset to be equally divided within those subparagraphs, they so stated, as in paragraphs 2 and 9 of the marital agreement. So with that, I would rest on our briefs and ask this court to affirm on the cross appeal and to reverse on for each of the reasons stated in our briefs. Thank you.
Thank you, counsel. Okay, I think we have a little bit of time left on the cross appeal. I think. How much is it? It looks like
I
it's
think I had just under a minute, Your Honor.
looks like it's 58 seconds. So I'll start you off with my question on this, and they'll start the clock as soon as you start to answer it. Is your cross appeal moot?
No, it's not, and because he did pay it, but and Your Honor's question went right to one of the dilemmas that I had when thinking about the case and thinking about the issue. So what the remedy, the problem was, and the wife herself acknowledged that the market for the Astura or the Height Holdings shares had dropped into the $60,000 per share range. And when she was asked during trial, would you sell it at that point? She said, no, I don't want to sell it into a depressed market. But the husband was then forced to sell his stock into a depressed market in order to satisfy a debt that didn't really need to be satisfied. The remedy that we suggested in our cross briefs is let the court have a hearing at which time the testimony can be established as to what money did the husband borrow to have to pay them the amount and what interest, if any, was done, and the amount between the $92,000 stipulated value of those shares, $90,000 per share, and the amount he actually had to sell to. So that's in essence the remedy, because he did have to sell into the depressed market. I see my time's expired. I'll stand on my briefs, and I thank the court for your questions.
All right. Thank you, counsel. And with that, we are in recess.
Thank you.
Thank you.